Tonight, we're going to talk about what actually happens after eviction is filed. This is especially for my landlords, some information to help my real estate agents, and then we're going to do something at the end just for the renters. What happens after eviction is filed? So tonight I'm trying something a little bit different. I'm going live on TikTok and Instagram. So if you see me looking back and forth, that's why. So my name is Itanya. I go by Real Estate by Itanya. I have 25 years of property management, 7 years as a realtor. I manage a building currently in the Bay Area that's 39 units. And we are actively handling evictions right now. I was just in eviction court 2 days ago. So I'm going to be talking about that experience, probably maybe a little bit tonight, but at a different time. And now let me say this clearly. This is educational information only. I am not an attorney. This is not legal advice. Every case is different. You should consult an attorney for legal guidance, especially if you got an eviction notice. But 25 years, I got some experience. I'm living it now. I just told you I was in court. So I am living it right now. So if you have any questions, you could put questions in there and I'll get to them. Otherwise, we got to get in here and talk about what happens after the eviction is filed. So let's start off with when filing starts the process. That's starting. So filing an unlawful detainer, that's what an eviction is called. It's called an unlawful detainer. That starts a lawsuit. It does not remove someone automatically from the unit or the property that they're in. It just starts the process. Again, this is general education information, not legal advice, but filing is your first step. This is for my landlords. Filing is your first step after you serve the 3-day notice or a 30-day notice, or depending on what county you in, what kind of notice you had to serve. So after the 3-day notice have expired, then that's when you file the unlawful detainer. Landlords, you could file that yourself. However, I do recommend that you get an attorney because we're going to talk about any delays if it's not filed correctly, if you don't understand your city ordinance, because different cities have different ordinance, then it could delay the process. So here's another disclaimer. You cannot serve your own lawsuit. You cannot serve your own lawsuit. So a landlord or a property manager listed in the case cannot serve the papers. It must be someone over the age of 18 who is not a party of the case. Often they have process servers that could serve it, but you can't serve it. You can have a friend serve it. You can have a family member serve it, long as their name isn't part of the case. Improper service of that notice could delay or dismiss your case. And again, this is educational information only, but courts may make that decision. So you cannot file it yourself. As much as you want to, as much as you want to save money. Later on, I'm going to talk about cost and fees. And this is just general information because I'm covering California. So it may be different in different states, but it's also different in different counties as well. And I'm going to give you a little tidbit what I found out from the attorney on Wednesday about Alameda County. So full timeline walkthrough. That's what we're going to go through now. So step 1, notice period. So I talked about that. You have to have that 3-day notice filed first. tenant has the opportunity to comply. So if the tenant gets a 3-day notice, they pay what's on that notice within the 3-day notice, guess what? We don't go to eviction. You can't take them to eviction. You can't start an unlawful detainer if they complied with the 3-day notice that was given to them. Okay, so if they didn't comply, so the 3-day notice has expired. Once again, I talked about this last week, and go look at some of my previous posts. But a 3-day notice, the days, it doesn't include weekends or holidays. So step 1, the notice period is the 3-day notice. Step 2, you file your unlawful detainer. Step 3, service of the summons or the complaint. So now you want to file the unlawful detainer paperwork. Step 4, the tenant response window. Last week I was saying I get 5 or 10 days depending. Well, I confirmed it's 5 days. 5 days. These are not business days. You got 5 days to respond to the paper. Landlords, they got 5 days, 5, to respond to the paperwork. So let's talk about what happens if they respond and if they don't respond. So if the tenant responds, a trial is scheduled. That could be within 20 days. No, it ain't. Well, let me say this. I'm doing all of California. So some counties, it could be within 20 days. I talked about last week the timeline. Most evictions, it takes probably about 60 to 120 days, 60 to 90 days before you even get close to a trial, just depending on how backed up the courts are. I shouldn't laugh, but 20 days is, I think, a little bit unrealistic. But maybe it's supposed to take 20 days, but it usually don't. But if the tenant responds, it could be delayed. And is this the time? Let me just put in here. So I'm in Northern California, the Bay Area, Alameda County. I know the most because that's where I'm at. That's where my evictions go. So I'm familiar with that county the most. And in Alameda County, we got something before you get to trial called settlement court. And settlement court is you sit in the hallway. And I just did this on Wednesday. You sit in the hallway until you have to be there at 9 a.m. to let the judge know that you're there. So we normally have an attorney. So my attorney, they let them know I'm representing. They representing us. We're here representing. And then you have until 3 p.m. So you got to come with the settlement by 3 p.m. So 9 a.m. to 3 p.m., you're sitting in this hallway on hard benches and you're going back and forth and you're trying to settle. So let me just kind of give a little example of that since I'm here. So what that is I got there at 9 a.m. My first settlement came probably about 10:50 a.m. We call them resident or your tenant. My tenant, they got an attorney that was representing them. And so the first settlement came in probably about 10:50, right before 11. And they wanted 90 days to move. I don't know if they asked for their deposit back, but they wanted 90 days to move and us to wipe everything that they owe clear up until that point. Nothing to be on their record. It was like, no. So we didn't accept that. So what we said is we want to keep the deposit. We would give them at least 60 days to move. and we will wipe their record clean. So at this point, overall, when you add the attorney fees and you add the time that they will be here and the time that they haven't paid and what they owe, we're in a way losing out on $12,000, right? So, we went back and forth. So we finally settled by 11:30. We settled, and the settlement was they will move out in 45 days. We keep the deposit. We clear their record. They don't know anything. They agreed to it. We agreed to it. Okay, so I'm like, I'm going to be out here before lunch. Wrong. I sat there on the hard benches, and I need to add that to my notes next time. Maybe when I post the video, I'm gonna talk about what I did bring, because I bring snacks. I brought, I made sure my phone was fully charged. I had my water. I had my iPad. I come prepared because I know it's gonna be a long day. That's settlement court, right? We paid $650 to sit in the hallway to settle this case. That's what the attorney charged us. I recommend you get an attorney. They are expensive, but my attorney, he was good. So he got us the 45 days. But it took them, the other side, it took them 3 hours. 3 hours to get the paperwork done. I had to sit there for 3 hours just for them to get the paperwork done that they already had a template for. They just needed to fill in a few words, print it out. I signed, he signed, it's over with. But no, they drug it out. So I don't know if his attorneys get paid by the hour, so they wanted more billable hours. I don't know. I'm not here to talk about attorneys. If you're an attorney, put it in the comments how that might work. I don't know. All I know is I sat there for 3 hours. Now, part of the 3 hours is because they have the wrong dates on there. We said 45 days, and I think March, April, May. So they gave them my 60, 75 days. I said, okay, that's not what we settled on. So they had to go back, redo it. Then we got it back again, and they left a clause out that my attorney caught. This is why it's good to have an attorney, because even though they had an attorney representing them, they left out an important clause, and my attorney caught it, and he was like, wait a minute, because we was going over he was going over and make sure I understood everything. He said, wait a minute, they're missing a clause here. Hold up. So he went back to them. We wrote that one in, luckily. I didn't have to wait another 3 hours for that one correction to be made. But that is settlement court. So that's how it works in Alameda County. I'm not sure about, it's not like this in Santa Clara County, San Jose area. It's not like that because my attorneys, that's where they're from. Alameda County. And I said, why is it so difficult in Alameda County? Why? And this is what they told me. They said Alameda County, they get a lot of funding from nonprofits who help tenants through the eviction process and going to court and all that. They represent the tenants. So there's a lot of nonprofits that get funding to do this. So therefore, it delays the process a lot. I sat there all day. We settled by 11:30. I had to sit there another 3 hours just to get the paperwork signed before I could leave. So that is settlement court. That isn't part of my notes. I wasn't going there, so that's a little tidbit for you guys. If the tenant does not respond, let's get back to our program. If the tenant does not respond, it goes quick. So, okay, I'm not an attorney, but tenants respond. Okay, so if the tenant does not respond, request for a default is filed. The court enters the judgment. The writ of possession is issued, and it just goes quicker. So usually within 30 days, the sheriff will come out, and once the sheriff comes out, that's a wrap. It's like you gotta know. I think they give you 5 day notice before they gotta come out. And that's when you need to have all your stuff out and you need to be out the apartment they come in. We changing the locks. We now have possession of our unit. But let me tell you what does happen. Okay. So even though the sheriff is coming out and if you leave stuff in the place, we have to hold your stuff for 15 days. So we have to hold your stuff for 15 days, even if, we won the judgment, everything. And if you don't come get it after 15 days, if it's something valuable, we could sell it and we could put that towards what you owe us, or we could toss it and throw it away. So even if the sheriff comes out and you have stuff in there, you got 15 days to come and get your stuff. Normally what we do, because I don't have nowhere to store people's stuff, and sometimes I get people that leave their whole apartment there. I'm like, you didn't take nothing? It took 6 hours one time for my workers to clear out an apartment because they didn't take nothing. But anyway, I'm sidetracking here. Just giving you some real life things. But so we just keep the stuff in there. So basically, although we have possession, we done changed the locks. We don't do nothing with the apartment for 15 days, just in case you do want to come back and get your stuff. That's your right. And if I had somewhere to put it, then I don't have to keep it in the unit, but we just keep it in the unit because we don't have nowhere to put it. So after that, the lockout happens. We get back possession, and that's it. The sheriff is enforcement of the court order. It's not automatic. It's not immediate. So you can't, when unlawful detainer is put in, the next step isn't, okay, here come the sheriff. It's still steps to the process. Oh, and let me just say this because I didn't finish. So if we was to go to trial, so the reason why we try to settle in settlement court, because if we go to trial, if we couldn't come up with the agreement in that hallway and we have to go to trial, then I think I'm going to talk about this later, but then you go to trial. Our attorneys charge us $5,000 a day. A day. And sometimes it gets dismissed, it gets continuance. If you ever have to go to court for traffic tickets or anything like that, sometimes it's, we're going to continue this later and all of that. So it's like, do we want to pay a $5,000 a day for that? And then during that time, we don't have possession of our unit. The tenant is still staying there and not paying us rent. And now I got to go to trial? So we try to settle our best. So why it seems like, we lost $12,000 of what they owed us, really, we could be losing a lot more because we got to pay an attorney $5,000 a day. And then sometimes when you go to trial, the jury is mostly composed of who? A lot of times it's composed of renters because there's more renters than owners. So you're going to trial, and even though you feel it's a clear case of this is rent, they didn't pay. Okay, I just need possession of my unit. The jury may be, they may come up. I don't know. I've never been to trial, so I can't really talk on that. So if I have any attorneys that have been to a trial, you could give a comment, let us know what happened. I've never been to trial because we've always settled. And our attorneys was like, we could go to trial if you want, but this is how much you're going to be paying me. Is it worth it? And we like, no. Clear the whatever they need, clear the record, whatever. We just want, at that time, most of the time, landlords, they just want possession of their unit. Just leave. So this is general overview for educational purposes only. I'm not an attorney. So let's talk about bankruptcy. So sometimes a tenant could file bankruptcy that may delay the case a little bit. So let's talk about it. So if a tenant files for bankruptcy, hopefully I'm saying that right, it triggers something called an automatic stay. What's an automatic stay, you ask? An automatic stay means that collection activity must stop. Like you can't collect that. Landlord can't collect the money. The court proceedings pauses. Eviction action may pause. And this is a federal law, not a state law. So it may be some delay, but landlords, you could still get possession back of your unit, but it's going to take some time because now you got to go to the bankruptcy court. And so the bankruptcy file is filed before the judgment. So the bankruptcy has to be filed before you file the unlawful detainer. So the eviction pause, the landlord may need to file a motion for relief from stay in bankruptcy court. So then the landlord has to go and to file a motion for relief from that stay. So the second scenario that could happen, that was the first one. The second one is bankruptcy filed after judgment for possession. In some situations, landlord may proceed. In other cases, it still pauses it. So a tenant, if they file a bankruptcy, is going to delay the process a little bit more while you're going through that. It's not forever, but it is a delay. So if the eviction is based purely on non-payment of rent, bankruptcy often pauses it. So if the eviction is based on illegal activity, threats, endangerments, there may be some exception, even if they do file for bankruptcy. But if they're endangering people or, they're threatening you, me, meaning the landlord, you're threatening my life, or you're doing some illegal activities out of the unit, then even if you file bankruptcy, it still may not delay it. But that is a fact specific, and the judge and the courts will decide. So let me add that disclaimer again. This is not legal advice. Bankruptcy is complex federal law. You should consult a bankruptcy attorney if this situation arises. This isn't do it yourself. Get you an attorney to explain this to you. Now let's explain the impact. So bankruptcy could delay eviction for weeks, sometimes months, depending on the court backlog. So for my landlords, this is your takeaway. If you receive a notice that a tenant filed bankruptcy, stop and verify immediately. Continuing action improperly can cause legal issues. So you don't want to ignore the notice if they do file for bankruptcy and be, I need them out my place. It's a tactic that a tenant could use, but it's a delay, but you just go through the motions and you'll get your place back. But definitely get your attorney. This makes you sound careful and informed, and that's what we're trying to do here. So hardship. What if a tenant claims hardship? I get it. Rent is high. Everything's high. Hardship alone does not automatically stop the eviction. However, a tenant may request a stay of execution, and that's extra time after the judgment. So if they're having a hardship, maybe they're trying to get rental assistance. I said this on one of the lives, 2-on-1, whatever county you in California. I'm not sure if it's in other states, but 2-on-1, that's like a social service hotline. They help you with rental assistance. They let you know what companies is offering help with your PG&E bill, help with food. If you need some medical, they call 211 and they're going to give you a referral to places, but you got to make the phone calls. But so hardship at court extension, and they may be able to make a payment arrangement. Courts could grant limited time extensions. So hardship does not erase the rent you owe. It may delay enforcement, but it won't erase it. Okay? So again, this is educational. Courts decide based on individual facts. So they have to see your situation. You're going to have to show some proof of what's happening, but it may you may get a time extension from it. So accepting late or partial payment. Landlords, this is where landlords get in trouble. If you accept rent after serving a 3-day notice, you waive the notice. You got to start the process over again. If you accept a partial payment, if you set $1, if you set $5, you have to start the 3-day notice process over again. You waive that notice, you may reset the process. If you accept a payment while you in eviction, you got to stop. Everything starts over again. If you accept a partial payment and they promise I'm going to pay you this day, and you don't get the money, you got to stop the eviction. Even if you take any payment, you got to stop the eviction. So this gets the landlords in trouble. They try to keep the money, and sometimes they try to still go through with the eviction. But as soon as the tenant tell the court, well, I made a payment, here go my proof I made this payment, here go the date I made it on, it stops the process. Some landlords include reservation of rights language, but this must be done carefully if they're claiming that. If your case is already filed, accepting rent could affect possession claim. Say this is the strategy matters, and this is definitely not legal advice. This is why landlords consult counsel before accepting money mid-process. So, no process, no money. I had an eviction. We went in October. They went up for eviction. January, we went to court. We went to, when I say court, settlement court. We sat in the hallway. And they negotiated 75 days. So that from October to the end of March, we don't get rent. October, November, December, January, February, March, 6 months. So let me just say this. So if someone owed you, let's say $1,000, they owed you $1,000, what would you do? Because legally, the law comes into play, so there's things you can't do. You can't go and go into their house and take their stuff. You can't lock the door. You can't mess up their car, not legally. But if they owe you $1,000, okay, and then you like, oh, okay, they said they got paid. So the next month, they owe you another $1,000. And then the next month after that, they owe you another $1,000. And then another. What do you do? And whether it's, oh, well, they don't have it, it's expensive. What do you do? I don't know. I think we act different when it's our money, but when it's other people's money, it's like, well, rent is high, rent is this, rent is that. It is high. But you know what? we get regulated. We got rent caps, we got ordinance, we got state law, we got city laws, we got federal laws that we have to follow. But guess who don't get regulated, right? PG&E. No one's coming to tell them, oh, you got to put a cap on that PG&E. The water company. Who's telling the water company, no, you can't charge that. You got to put a cap on it. What about gas? Who's telling them, oh, no, you can't charge that much for gas? All these expensive. The garbage company. Cable. There's no caps, there's no regulation on what they could charge. But when it comes down to rent, when it comes down to buying a house, when it comes, you got all these oh no, you can't do that. Oh no, you can't do that. Oh no, you can't kick them out. Oh no, we have a homeless issue. So we're going to make you, the landlord, solve our problem and house people because the city got a homeless issue. Okay, that's fine. I will house them, but give me some funding to keep them. Even in the eviction moratorium, we had to prove for the landlord to get the money, the tenant had to prove that they couldn't pay. But for the tenant to get the money, all they had to do was say, I don't have it. They didn't have to prove nothing. But for the landlord, they said, well, the tenant has to show proof that they didn't have the money in order for us to give you your money. Like, what? Make it make sense. It doesn't. So I help a lot of landlords. I do tenant placement. I help a lot of small landlords that are good people, that try to do the right thing, that don't raise rents, that take care, that help pay utilities, do all that to help people. And sometimes they get screwed. And I understand renters too. I try to help them find housing. When I'm doing a tenant placement, I'm dealing with the renter. I've been a renter. I get it. But sometimes you got some people that's not right, they're not fair, and they do shady stuff to get over. And let me just say this, and then I'm going to get off my little tangent. We do have places, we have things in places to help people that don't have the money, that need housing, that get affordable housing. It's called the Housing Choice Voucher, Section 8. Housing Authority, affordable housing. That's what that is. And you know what? Because I get my landlords telling me too. So their portion is $50, Tanya, and they're not paying me. Their portion is only $100. They're not paying me. So what is that? You get affordable housing. Your housing is paid. You just responsible for $50, $100. And you still can't pay it. What's that about? Off my tangent. Sorry. That wasn't part of the notes either. But we gotta make it make sense. Put it in the comments if you don't agree with me or something. Let me know. So what if the notice was wrong? So I talked about the payment. What if the notice was wrong? Common mistakes. This is for my landlord. So what if the notice was wrong? The amount listed was wrong, included fees not legally allowed. So when you do it, it can't include late fees, pet fees, parking fees, that sort of stuff. Incorrect dates, improper service. You try to serve it yourself. You cannot serve an unlawful detainer yourself or anyone involved in it. It's defective. The case could get dismissed if there's like errors in it. That means that the notice has to get reserved. You have to wait the full notice period. So filing an eviction in California could take anywhere from 60 to 120 days, depending on what county you're in. So you have to refile the case. You have to pay the filing fees again. I had some examples of the filing fees, and I don't see them now unless I skipped over it. Let me take a look. maybe, is it on this? No. Okay, I could get that information, the filing fees, precision matters in an eviction. And you know my little disclaimer, I'm not an attorney, this is just educational information for you. I'm going to see if I could get to the notes real quick about the filing fees. So while I'm looking for that, I'm going to talk about the renters just briefly, just for my renters. We're almost done here. Renters, if you are a renter and you're watching this is not legal advice, but educational only. If you serve court papers, if you are served court papers, do not ignore them. Don't ignore them. You got 5 days. That is not business days. Those are calendar days. The weekend includes in your 5 days. You got 5 days to respond to that paperwork. If you are served court papers, do not ignore it. You have a response window, the right to file an answer, the right to seek legal aid. You cannot be locked out without court judgment, a writ, or sheriff enforcement. And you read every document carefully, seek legal aid. I don't know about Alameda, about other counties. I'm going to tell you about Alameda County only because my tenant, he sent me a copy of the paper. On his paperwork, it told him, you know, he had his 5 days to respond. It gave him a list of attorneys that he could call for help. I'm like, wait a minute. I was looking on my paperwork. Well, where are my list of attorneys that could help me? But they gave him a list of attorneys in the county that could help him. Now, keep in mind, like I said earlier, Alameda County, they are the county that has the most nonprofits that help tenant protections. So that's why that's happening, because they get a lot of attorneys, a lot of nonprofits that help the tenants. So that's why I'm not sure if it's on everybody's paper, but Alameda County, they got something going on with the court, and they even have tables in the courthouse. When you go to eviction court, if you don't have an attorney, when you go in there and you get off the elevator, usually the right-hand side, that's the renter side. The left side is the landlords. But right there, as soon as you get off that elevator, it's like 10, 20, 15 attorneys there. It's like, can someone help me? But when I say me, I'm representing the landlord. But yeah, they do. And I'm not saying it's bad. I think that it's great. My position is I want both parties, the landlord and the tenant, to understand the laws. And that way we could all live happy together because we know our rights, right? We know what's wrong and not wrong. All right. So I want to just recap what I said for the landlords. So this is like the Cliff Note version. If you don't want to listen to the whole video, you don't want to go back. Landlord Cliff Notes. Here's a short recap version. Filing an eviction starts a lawsuit. It does not remove the tenant. After filing, the tenant must properly be served. The tenant has 5 days to respond. If they respond, a trial is scheduled. In Alameda County Settlement Court is scheduled before the trial. If they don't, a default judgment process. So that speeds it up quicker. After judgment, a writ of possession is issued. A sheriff's posts 5-day notice. So they'll post 5 days letting you know that the lockout is about to happen. And then the lockout happens. So you have to be out the unit by then. Delays could happen due to court backlog. I told you right now in most of California, Not all counties, but LA County, San Francisco, Alameda, San Jose, 60 to 120 days for eviction, 60 to 120 days. So that's the court backlog, filing mistakes, hardship requests, bankruptcy filings could delay it, typical costs, filing fees, process server, a sheriff fee, attorney fee, lost rent, turnover costs. So eviction is legal and financial. It is not immediate. It is not emotional. It's not structured. This is informational only. So let me do my disclaimer. I was looking for the fees. I couldn't find them. But what I'm going to do is when I post the video, I'll add the fees on there. Because I thought it was going to be quick. But anyway, so just my final disclaimer. Everything shared tonight is for educational purposes only. It is not legal advice. Eviction is structured legal process, not a threat. It's not an overnight event. It's not something to handle emotionally. They owe me money. I'm not, no, I don't want to settle. No, I don't want to do this. No, I want to do that. Okay. I don't know how much other attorneys charge. All I know is my attorney, they said we charge $5,000 a day for trial. And we was like, let's settle. We want to settle. I don't know how much other attorneys charge. If you are a landlord or a real estate agent, education protects your investment. If you are a renter, education protects your rights. So know your rights, right? So that's kind of all that I have for tonight. I haven't put up the eviction yet, but in my stand store under Real Estate by Tanya, I do have the 2026 California laws in there that you could download for free. I have the 3-day notice process, how that works. You could download that for free. And then I'm going to be having like some of the eviction checklists and what happens and that sort of stuff. And I got just a few counties. I got one for San Francisco, Oakland, Los Angeles, and then just the overview for California on that process. Each county is a little different. They have different ordinance and that sort of stuff. But that's on there that will be on there for free. It's not now. But and also if you're a landlord or even a renter and you just need some more help with your situation or understanding it, I'm live every Thursday. I'm going to be going live on Tuesdays during the day, but I also have one-on-one clarity calls that you can schedule a call with me. Like I said, I'm not legal, but I've been doing it for 25 years. So my call is nowhere near what an attorney would cost. And I may be able to guide you, point you, or help you. Let me make sure I don't have any questions. And that's going to be kind of it for the night. I appreciate everyone for popping in and joining. And hopefully something was learned about what happens after the eviction process. So next week, I'm going to be going just a little bit more detail in this as well. And then I think that's going to be the end of the series. So this series was, Did You Pay Your Rent? And we started with what happens when you don't pay your rent, the 3-day notice. Now, what happens when you go to eviction? I just really explained my experience because it's just fresh on my head about settlement court in Alameda County. And then we're going to be talking about next week after the eviction, right? Like after you get the sheriff come and lock you out, what happens next? Does the eviction show up on your record? Do you, is it going to be on your credit report? So we're going to talk about that next week. So join me next week, 7:30 live. I'm going to be on Instagram and TikTok. So thank you for